Officer Dave, would you open the courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. Let's start with Papa. Good morning. What file do you have today?
Today it's LVNV v. Cooper.
Got it. Okay. Put you back in the waiting room. Don't have your client as an attorney, opponent as of yet.
No problem.
Good morning.
Good morning, Your Honor.
What file do you have today, sir?
It's 22-182021.
And you are representing whom?
Affiliated Diagnostic.
Okay, so you dollar.
Yeah, I apologize in advance. Mr. Ferderstrom lost internet and power, so I'm a last-minute substitution.
Ha
But we're ready to go.
Okay.
That's why I do not have a tie.
That's all right. We'll live without it. Put you back in the waiting room. I don't have this porter as of yet.
Okay, no problem.
Hello?
Yes,
What is your name?
Jermaine Cooper.
All right, let's get started. All right, we are on the record. This is file 07-157-353 LVNV funding versus Jermaine Cooper. Your appearances.
Good morning, Your Honor. Alexander Popov, P84378, appearing on behalf of plaintiff.
And your name, sir?
Jermaine Cooper.
All right, this is the motion filed on behalf of the defendant for reconsideration of the court's order concerning the order of garnishment and his motion to set aside default judgment. Mr. Popov, what's your position on this?
In response to the motion for reconsideration on the garnishment, the proceeding on the garnishment itself is valid. He is attacking the underlying judgment, which is why I believe he filed a motion for to set aside the default. But the garnishment itself is valid.
Yeah, I agree. There's no error in that regard. What about the motion to set aside the default judgment?
Yes, Your Honor. So given the fact that this file is quite old, it looks like from the records that we have, the account was opened in November 24th of 2004. The plaintiff filed suit against the defendant in 2007. It looks like, and I attached the ROA, the Register of Actions, that the defendant was served on January 30th of 2008.
Yeah, that's the problem that I have. Attached to the defendant's motion is a copy of the Register of Actions from the circuit court in a criminal case involving the defendant, and that is case number 07-00-61201 FH. That proceeding before the Honorable Deborah Thomas indicates that on March 30th, 2007, which of course would precede January 30th of 2008, the defendant was sentenced to an adult sentence to the Michigan Department of Corrections for 2 years for the felony firearm. That 2-year sentence is a calendar 2-year sentence. So that from the court's perspective, there is no doubt that at the date and time of the purported service, that being January 30th, 2008, the defendant was in custody. So I'm having a big problem with the claim of personal service here. Now, I understand that in order to set aside a process service affidavit, clear and convincing proof must be demonstrated. I don't know how you get much more clear and convincing proof that the defendant was incarcerated, therefore could not have been personally served.
Your Honor, I agree. I can't say that I don't know the defendant was served in prison. And I think that the defendant does have a very good candidly speaking, he does have a good argument on having good cause, the good cause prong of setting aside a default judgment. I will say that he hasn't presented a meritorious defense. His argument is based on that he couldn't have opened the account because he was incarcerated, which isn't true because the account was open prior to the defendant being incarcerated. Furthermore, plaintiff would argue that defendant was released from prison in February of 2021. And plaintiff has filed multiple garnishments on 2021, 2022, and now 2023. He hasn't disputed the debt since he's got out of prison, and it's been almost 3 years, over 2 years now, and now he's trying to set aside the default. And plaintiff would argue that if the court can as well, in addition to setting aside the default, I believe it's MCR 2.612, can grant a motion for relief of judgment. In this instance, I believe it's, I have the court rule in front of me right here. 2.612, if the defendant's not personally notified, he has within a year to contest the final judgment. But there's also a prong, which it's basically a catch-all. I believe it's C4, any other reason justifying relief from the operation of judgment. In this instance, plaintiff would argue that in going by the case law, in these instances, it's usually instances of fraud, duress, or coercion. Courts would be inclined to vacate the judgment, which plaintiff argues that that's not the case here. Furthermore,
What would you call filing a proof of service that I served Johnny Smith when in fact I did not serve Johnny Smith, if not fraud? What would you call that, sir? Is that an oopsie?
Your Honor, I'm
looking at 612 and I don't see an oopsie listed.
I'm inclined to agree. We got the substitution of attorney in 2018, so I can't speak on behalf of what the prior law firm did. I don't have the proof of service on me. It's an old file. I couldn't get a copy of the proof of service. And we would argue that the motion wasn't made within a reasonable time. It's almost 14 years. Yeah.
Thank you, Mr. Popoff. The court is prepared to rule in this matter. The court is taking a look at MCR 2.612, which provides for relief from judgment or order. MCR 2.612 C1C says on motion and on just terms, the court may relieve a party or legal representative of a party from a final judgment on the following grounds. And I think 1C is applicable: fraud, intrinsic or extrinsic misrepresentation or other misconduct by an adverse party. As we have discussed earlier, the records of the Recorder's Court indicate that the defendant was in the custody of the Michigan Department of Corrections at the date and time that he was purportedly served. I also know that MCR 2.612 C3 This sub-rule does not limit the power of a court to entertain an independent action to relieve a party from a judgment or proceeding to grant relief to a defendant not actually personally notified as provided in sub-rule B, or to set aside a judgment for fraud on the court. The court finds that the proof of service filed here was a fraud on the court. The judgment in this matter is hereby set aside and vacated. You have an absolute right to appeal my decision. That appeal must be perfected in 21 days today in the Wayne County Circuit Court. We'll send out an order. Thank you both for coming in. We are off the record.
Thank you.
Your Honor.
Have a good day, Council.
You too.
Good morning.
Good morning, Your Honor.
This is file 22-182021, Affiliated Diagnostics of Oakland versus City of Detroit. Your appearances.
Jordan Dollar on behalf of Affiliated Diagnostics,
Bar number.
P75674.
Tricia Porter on behalf of the City of Detroit, P66989.
Okay. I inherited this case from Judge Giles. So my first question is whether or not the January 10th case evaluation went forward.
I have to look at my file, I'm sorry.
I do not see it on mine.
Nor do I.
Okay, so I presume it didn't go forward. I have before me a motion filed by defendant for summary disposition based on the 1 year back rule. And there is also a motion in regard filed on behalf of the defendant in regard to plaintiffs or the motion to dismiss for lack of cooperation appearing in deposition. Before I go into the 1 year back rule, let me make sure I understand the factual scenario here. And correct me if I'm wrong, because I'm wrong a lot. I want to look first at the motion to dismiss for failure to comply with specifically the court order here in regard to the deposition of the plaintiff. My understanding is that prior to October the 5th of 2022, October of 2022, there had been deposition of the underlying claimant had been noticed 5 separate occasions, and that this individual never appeared. Then on October 14th of 2022, there was a stipulated deposition date that was supposed to occur, and the defendant underlying plaintiff again did not appear. That was a order in relationship to track 2 on the discovery order per Judge Giles. There was another deposition set after that failure on December 2nd, 2022 of the underlying claimant and the caregiver, Mary Hanson, and neither one of them appeared. Is that pretty much an accurate factual scenario?
That was accurate at the time that the motion was filed. We did, since the motion was filed, we were able to take the plaintiff's deposition. So he did testify as to an accident that happened. However, there is still, other than his testimony that this accident happened, we've investigated and we've got no, he said the police were there. He said the DDOT police, the transit police were there. He said he went in an EMS to the hospital. And unfortunately for the plaintiff, there are no records at the Detroit Police Department. There are no records of any EMS. There are no records of any Detroit Department of Transportation accident report. And we have nothing to support this injury or accident, that the accident even occurred. I think the plaintiff's mistaken somehow or is not being truthful. And so my motion was, when it was the motion for no injury, is more of a lack of proof that there is no injury in this case there's no evidence of injury in the case that this plaintiff affiliated diagnostic has produced in response to our motion to summary disposition, rather than a failure to cooperate in discovery, because there's just nothing to show that this actually happened.
Mr. Dollar.
Well, Your Honor, I think the defendant has just said that there is evidence. The underlying patient himself has testified in a deposition that we weren't provided notice of, but I'll have to take the defendant's word on it. But that's not what the defendant's motion that's before this court is about. The defendant's motion was about non-cooperation in a separate case. As we've argued, it's a non-party witness to this case. We fully cooperated. If the defendant wants to bring a motion on that basis of striking the witness for some reason, looking at the Dean factors, for discovery purposes, that's something different. But, we fully cooperated. We haven't been provided notices of any of these depositions. The defendant just keeps adding on arguments that aren't before the court.
May I reply, Your Honor?
Please.
I did file a reply brief that pointed out that the motion is not based on a failure to cooperate because that deposition was noticed in a separate action, the plaintiff's action of Mr. Strickland. This action, the motion is based on, if you look at the motion, that there's no proof of injury, and the plaintiff did not submit any proof of injury in his response to our motion to dismiss. So it's an MSD based on lack of proof of injury, not a sanction, because if it was a motion for a sanction for failure to produce cooperate in discovery, I would have discussed the test that the plaintiff put forth in their response to our brief. There's a lot of factors the court considers before and whether other discovery sanctions that are less serious are appropriate. None of those are relevant here because it's the plaintiffs who is admittedly the real party in interest in this case, affiliated diagnostics burden to prove entitlement to no fault benefits. And part of that proof depends on proof that an injury in a motor vehicle owned by the city of Detroit, that element has not been proven. And I don't believe it can be proven in this case, even if I provide the plaintiff with the deposition testimony. The deposition testimony has no support in fact.
Okay, here's the situation. Your motion in regard to seeking dismissal for lack of cooperation with discovery in violation of the court's order in that regard is going to be dismissed as moot. The remaining motion is your motion for summary disposition based upon your claim that there is no demonstrated proof of injury. The problem is that in granting a motion for no proof under MCR 2.116C10, the court is required to be liberal in finding the existence of a genuine issue of material fact. As you yourself advise the court, and I appreciate your candor, at his deposition, that is under oath, the underlying plaintiff said, I was in an accident and I was hurt.
I understand.
I cannot judge credibility on a motion for summary disposition. The question is whether under a C10 motion, there is any admissible evidence tending to show the genuine existence of a genuine issue of material fact. The question of whether or not the plaintiff is credible or not is a question to be determined by the trier of fact. In this case, given the fact that the underlying plaintiff has testified that he was involved in an accident and that he was injured, and that testimony was had under oath, that's admissible evidence sufficient to defeat a motion under MCR 2.116C10, no genuine issue of material fact. The motion for summary disposition filed on behalf of defendant City of Detroit in regard to the no existence of injury must therefore be denied. Now, I have one more matter for you people. I have a motion for summary disposition on the basis of the 1 year back rule. I'm going to adjourn that motion for 2 weeks. And the reason for, well, 3 weeks actually. The reason for that is that within the last week, the court saw a couple of decisions by the Court of Appeals construing the tolling that was ordered during the pandemic. And neither of you, in all fairness, it wasn't before you, neither of you addressed that in the motion. So what I'm going to do is I'm going to adjourn this matter for 4 weeks. That'll be until March 24th at 10. And the only thing we'll do at that point in time, we will hear the defendant's motion for summary disposition based on the 1 year back rule. That will give both of you an opportunity, should you choose to do so, to supplement your pleadings now that we have at least some minimal guidance as to how the tolling is to be under the pandemic situation, obviously a situation we never had before, is to be construed. So 3 orders. 1 order adjourning to March 24th, the motion in regard to the 1 year back rule.
Mhm.
1 order denying for failure to make discovery. 1 order denying for no injury. Okay. Now,
Okay.
how much are we arguing about? You know, again, I'm inheriting this case. How much are we arguing about here, Mr. Dollar?
The total bill is $14,250.
Okay. Here's what I'm going to do. Depending upon, and I don't want to prejudge because I haven't seen your supplemental pleadings. My decision in regard to the 1 year back rule as interpreted in our recent cases. If the case is still surviving, then I guess my next step would be to set it for case evaluation. Because apparently for whatever reason, the January 10th case evaluation did not proceed. So that's my decision. 1 adjournment to March 24th, the 1 year back rule. You can file supplemental pleadings. I would urge you both to do so. Order denying summary disposition based on no injury. Order denying dismissal based on failure to cooperate and make discoveries ordered by the court. Anything else we can accomplish today?
No, thank you, Your Honor. I'd be happy to submit an order.
Oh,
Yep.
That'd be great.
Okay,
You submit the order denying those 2 motions. And then
All right.
I'll go ahead and I will send out the order adjourning the motion for summary disposition based on the 1 year back rule to March the 24th at 10 o'clock.
all right, will do. And should I fax it to the court?
That'd be great.
Okay, will
Thank you
do.
both for coming in. Mr. Dollar, you did a
Great.
good job filling in.
Thank you. I
Thank
appreciate
you.
that.
One
Thank
of
you
my
both.
colleagues like rode up with the elevator today. I won't say who she is, but she's in the dark too. She doesn't have any power.
Oh, I don't either.
Really?
Really?
Yes.
She was told no power until Sunday night.
Ugh.
Yeah, no,
gonna
Mr.
be a-
Ferguson thought he had it last night and he said it went back out and went off again, so.
Yeah.
Oh,
I'm in a condo now, but I got to tell you, if I were in a single family home, more and more, given the climate changes that are happening, I'd have to be thinking about a generator for the house.
Yeah.
we definitely are. I agree.
I mean, it sounds like an incredible, my retired court clerk lives out like far out in Macomb County. And she's got a generator. And every time it rains hard, she loses power.
Mm,
Oh,
Rather than throwing out a refrigerator and freezer full of food every time it happens, spending money to go stay in a hotel and aggravation and all that, they went ahead and put a generator in. She's been very happy with it.
yeah, we're gonna
Yeah,
do
they-
that too. They're expensive, but I think well worth it.
Well, look at it this way. After you got what, as I recall, you have 24 hours for the food in your refrigerator if you don't open the door.
Hmm.
You have, I think, 36 or maybe 40 hours for the food in the freezer if you don't open the door.
Hmm.
And everybody's freezer is always on jam because you
Mhm.
don't want to, hey, I don't want to go out and we have something. Okay, so that food is gone.
Yeah,
Food is gone.
that's true.
Then you're gonna have to get, you might stay maybe 2 nights in the dark. But somewhere around the 3rd or 4th night, you say, oh, I'm not doing this anymore.
Yeah.
Yeah,
So then we got a couple $100 a night for hotel and meals.
right. And all the disruption and lack of power, lack of ability to work.
Yeah, and of course,
Yeah.
Edison doesn't pay any of this.
No,
No.
So it's a really tough situation.
it
Okay.
is.
Ms. Porter, 2 orders from you.
Yes,
Everybody else, 1 order from me. March 24th at 10 o'clock. We'll be together next.
all
Great.
right.
Thank you, Your Honor.
Thank you, Your
Thank you for
Honor.
coming in. We're off the record.
Right.
Let's be safe out here and I hope you get the
Yes.
power back. You have any,
Thank you. You have a good day.
you have any estimate when you get power?
No, Sunday, like the person you were
Still
talking
on
to.
Sunday.
Yep,
Wow.
Sunday. It's long, gonna be a cold weekend.
Yeah.
Absolutely. Be safe, be warm.
Take care. All
Thanks, Mr. Dollar.
right. Thank you. Bye-bye.
We're a fool.
The world is ours. Until nine. 1 year ago today, Russian troops invaded Ukraine. Across Ukraine, the grand anniversary is being marked in defiance. And in support of those fighting that continue with no immediate end in sight. Margaret Evans.
The video message delivered this morning by Vladimir Zelensky in Ukraine was standing. Zelensky is a man much changed from the past year, now a real-time leader known to the whole world. Ukrainian people too much change. In Kyiv, 75-year-old Valentina Kasan is down the road. I'm married my son, who died in service, she says. And also married her husband. They got nothing up with retired battleground, the Donbass, the tanks lumbering along snowy roads and forests. Fighting them, same thing. They do. And I mean, I think
China is calling for a ceasefire in Ukraine.
Morning, council.
Good morning.
What brings you here this morning?
I'm here on a motion to reinstate
You represent the defendant or the plaintiff?
plaintiff.
All right, we'll see what's going on. I don't have your opponent as of yet. Put you in the waiting room. Good morning.
Morning, Your Honor.
What brings you here?
Jesse Halfon, I'm standing in for Cheryl Ronk on the case of Complete Imaging versus City of Detroit. I have a motion to reinstate.
Going forward, Mr. Halfon, either call yourself an attorney, put a P number on it, or case number. Otherwise, I don't know why you're here. And on a
Gotcha.
busy
Sorry
day,
about-
you'll be at the end of end of the call.
When I place my name on the record, you're saying in the caption in the Zoom,
Right, we're in the Zoom. Yeah, I don't remember. You're in my waiting room.
gotcha.
Unmute, counsel. We are on the record. This is file number 20167-228. Complete Imaging versus City of Detroit. Motion to reinstate dismissed case. Your appearances.
Good morning, Your Honor. Tracy DeVries on behalf of the plaintiff, P84286.
Trustee Halfon, P66936, standing in for Cheryl Ronk, appearing on behalf of the city of Detroit.
Okay. Did you file a response to this motion?
No, we have no objection to reinstate. We understand that there's a notice issue. We had our own default against us at some point because we had not received notice. Then I think there was a misunderstanding when we had the case moved to counsel within the city of Detroit. They, I think, probably mistakenly filed a dismissal, but we have no objection to reinstating the case.
All right, then what we'll do is we will reinstate the case by agreement of the parties. The next pretrial date will be March 24 at 11 o'clock. You'll get two orders. There'll be an order reinstating the case by stipulation. There'll be an order setting your case right here in March 24 at 11 o'clock. Now, Mr. Vries, while I have you here, what is the amount you're claiming here?
The current outstanding amount is, let me pull that up really quick. $20,100.
Because this case was dismissed back in 2021.
Correct.
And had it not been for the stipulation of the parties, I would not have reinstated it. I'm very concerned that given this lack of time and your client's apparent ongoing treatment, that we are past my subject matter jurisdiction. So before we are together next time on March 24th, please confirm that the amount in controversy is still in my subject matter jurisdiction.
I've already confirmed that it is, and it won't increase.
It won't increase any further. Okay.
Correct.
March 24th at 11 o'clock, you'll get two separate orders. There'll be an order calendaring the pretrial, and there'll be a order reinstate the case by stipulation of the parties. Thank you both for coming in.
One thing to note, Your Honor, before we leave, there is a second case that was filed for complete imaging on behalf of this defendant, handled by, I understand, Jason Proctor of Navarro Law. And so we farmed that out to make this even more unnecessarily complicated. We farmed that out to outside counsel. So there's a second case out there. I don't care which one goes forward, but I need to know where to send my, motion for summary disposition or whatever, how we're going to handle.
So the second case, it is confusing. The second case, these dates of service were basically split. We filed first before a plaintiff firm, and we have this set of date of service, and then the dates past are with another firm. But I believe that I thought that case was dismissed on discovery violations.
We're no longer handling it, so it's not in my system, unfortunately.
Okay, it's my understanding that that case is no longer an issue, and these are the only two dates of service that are still remaining for this claimant.
So in any event, what's relevant to me is my headache. So whatever else is going on out there is not my issue. And we are comfortable that the amount in controversy still is within my subject matter jurisdiction.
Correct.
March 24th, 11 o'clock. Thank you both for coming in.
Thank you, Your Honor. Have a good weekend.
Y'all be safe. We're off the record. That's going to conclude the morning call.